Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi weekly, every 2 weeks telephone call for the community. Today is February 20th, 2020, and as you would have heard when you logged in, this call does not create an attorney client privilege, and we take no guarantee for the information we provide. We are speaking based upon the information we do have and doing our best. Let me just make sure that everybody can hear me. Give me 1 second.
The conference is now in conversation mode.
Can you guys hear me okay, folks? Can you hear me okay?
Yes, Rajiv.
Excellent, excellent. Thank you.
Yes.
Okay, very good.
The conference is now in presentation mode.
I have told the team to keep the questions below 15, but they always end up going a little bit over because I like to have a little bit extra time to talk with everyone and not be pushed for time. But it is what it is, so we'll do the best with what we've got. The first question I have marked as a frequently asked question deals with the I-140 issues. I've been dealing with I-140, its approval, its impact. I think every meeting we've had, but there are always some new issues that come up. So the first frequently asked questions talks about I-140 issues, getting a copy of the approval notice, leaving an employer when the I-140 is approved less than 180 days, etc. So let me address that first of all from the very basic issue. What if I don't have a copy of my I-140 approval notice? Can I get it? And the answer is, I'm not sure you can be guaranteed obtaining it, but that should be okay. It's not a problem. Why? Because think about it this way. And if the government misbehaves, we'll be happy to take them to court. And that's what the good Lord made the courts for. Think about the position they are putting us in. I-140 is the application of the employer. That's fine. We agree. But there is a part of the benefit that goes to the employee. And those are two specific benefits that come with the I-140 approval. And I want to correct, I think, what was the name of the gentleman who posted this? No, lady, Nisha. Nisha says that as per the new rule, I have to wait for 180 days to get the benefit of keeping the priority date. Nishaji, that's not true. The way it works is, these two benefits that flow to you with the I-140 approval are as follows. The moment your I-140 is approved, the priority date is yours, even if the employer turns around and revokes your I-140 that same day. So as long as your I-140 is approved, the priority date is immediately yours. There is no 180 days there. Your priority date can be taken away if the government finds some gross error in the I-140 approval or fraud or misrepresentation. These are rare things. So the priority date is yours the moment the case is approved. The second benefit that flows, that has to wait 180 days. So not only must your I-140 be approved, it must stay unrevoked for 180 days. Then you inherit the second benefit, which is to extend your H-1B through any employer for beyond 6 years of the original H-1. So these two benefits belong to you. The petition belongs to the employer, fine. But if you don't give me a copy, Mr. USCIS, how am I supposed to prove my case to you? How do I prove that I'm entitled to that priority date? How do I prove that I'm entitled to extension of the H-1? I don't have a copy of it. And the answer to that is, because this is such an odd situation, I have had no problem both in invoking the priority date of the case as well as getting H-1B extensions without having a copy of the approval notice. Because remember, your petition can be tracked with your social security number and your name. So we have done this many times before. It has worked out fine. Despite Trump administration's attempt to tamp down and resist even legal immigration, we've been okay so far. The important thing to remember is there is a provision in the law. It's free of charge, and most of you know it. You folks are pretty smart people. And that's one of the things I enjoy working with you about. you can file a Freedom of Information Act request. You can do it online and ask for all your immigration documents. The government provides them to you free of charge. They take time, excuse me. Excuse me. They take time, but it's free of charge. So file a Freedom of Information Act request and get a copy. Many times, USCIS releases the I-140 approval notice copy along with the Freedom of Information Act documents. So my advice would be, one, don't worry about it. You're going to be okay. Even if you don't have a copy, try to get it. Two, file a Freedom of Information Act request. And three, check into the rules of ethics for the jurisdiction in which your lawyer is admitted. This is very important. In Virginia, where our offices are, we have 2 offices in Virginia, and it's right at the border of Washington, D.C., about 2 miles from the White House. But it is in Virginia. So even though I'm admitted in D.C. and Virginia, I obey Virginia rules as well as D.C. rules. And Virginia rules are very clear. They say, even if you have no contract with the employee, Mr. Lawyer, the employee has complete access to his file. So if you were the client of our firm and you called and said, I want a copy of my file, I would have to give it to you. That's the rule. That's the rule under which I work. So of course, there are, if an employer says, I want to keep my tax returns, for example, confidential, they will then have to get a separate confidentiality agreement with you. Virginia Bar has told us what to do. It gets a little bit more complicated. It can be done, but there's a procedure for it. So it may be the same for the lawyer who represented you. Even if they did not represent you, even if they never signed a paper with you, if they filed your immigration paperwork, they might be responsible to provide you a copy of the file. And if they don't, you can always take it to the bar. And the bar is very tough on us. They want to protect everybody, so they make sure that we don't step outside the line. Okay. So these are the 3 approaches. 1, don't worry. 2, do the FOIA. And 3, approach and see if the lawyer can give you a copy and put it in writing. Send an email. Our paperwork, all our paperwork informs both clients. I cannot hide your papers from your employer, and I will not hide your employer's papers from you. That's the rule under which we work. Okay. So now Nisha's questions specifically were, do I have to stick to the employer for 180 days? And the answer is no. There is no such rule. And I mentioned this a couple of times before, but I'll mention it again. It's a little bit different context, but it's the same idea of staying with that employer for 180 days. So we had a case that we were representing an employee. The employee moved to another state, and to a different employer. They still wanted us to represent them. And we continued. We got a waiver from the old employer and we continued to represent the employee. This was in Minnesota. The employee goes to the interview and USCIS denies his case, saying that you changed employers before your 485 had been pending 180 days. There's a parallel, 140 pending 180 days, 485 pending 180 days. And so we're going to deny your application because you're not eligible for AC-21. And we wrote a very strong motion to reopen, stating that this is garbage, you are misinterpreting the law. The law only requires that the individual who's filing for their green card are not questioned for 180 days. So as long as their case was not questioned for 180 days, whether they stayed with that employer for 1 day or 200 days doesn't matter. If the case stays pending for 180 days, that's all that matters. You didn't question it, it stayed pending. So they refused to accept. A lawsuit was filed, and immediately the government settled the case and backed off. So this is a misinterpretation of the law. If they tell you that you have to stay with the same employer for 180 days, that is not the law. The law is the case, the I-140 must stay unrevoked. That's an important distinction. So can you switch employers? Yes, you can. The key thing is, at the point when the I-140 was filed, You, the employee, did not have the intention to go away. But later on, if the intention changed, that's fine. Okay. Okay. So now the new employer says they will file for a 3-year extension, but to grant 3-year extension in the hands of so have not completed 180 days. I don't think that's a problem. Okay. Um, Now, can USCIS go and try to revoke your I-140? Yes, they can. And that bothers me a little bit because there is a provision, and I've seen this done. When somebody changed before 180 days, they did come after the person for getting their I-140 revoked. So, can you do it? Yes, but if you file an H-1B, if you were on H-4 EAD, no problem. If you were on EAD in general, 485 based EAD, no problem. But when you're on I-140, theoretically, there is no problem in changing jobs before 180 days and still keeping your right to extend the H-1 with the new employer. But they do try to get at your I-140. That is all thanks to the Trump administration. Because even though in theory and in the books that right should not be attacked, they do. So what is the best practical solution? The best practical solution is to not apply for an H-1B until 180 days of the I-140 approval are over. That would be the cautious approach. But if you are aggressive and you want to see what the government does and you want to test this out, I don't see why not. Because if you look at the I-140 regulations, there are two ways the I-140 can be revoked. One is if the employer requests it. And two, I don't recall all the details. I haven't looked at the law, but that's something to look at. If you want your lawyers to look at it, or if you want us to look at it, we can certainly charge you a consultation and take a look at it for you. But I don't remember the exact reasons for which they can revoke. Can they revoke the I-140 if the employee just leaves and the employer hasn't withdrawn the I-140? I think that's legally suspect. They try to, but I think it's legally strongly suspect. What if the employer wants to hire you back? They are allowed to keep their I-140 in play. They have paid a fees for it. So I think it's legally suspect, but it's not an easy answer. They cannot take away your priority date at all once your I-140 is approved, unless there is fraud or gross error. They cannot take away your right to extend H-1B beyond 6 years if the I-140 stays approved for 180 days. But should you change jobs before? And the answer is depends upon how aggressive you want to be. If you get a really good opportunity and they are willing to work with you and the old employer is standing with you, it might be worth the risk. So it's difficult to give you an answer in the abstract. Okay. Nisha, I also combined a second set of questions and I think I kind of messed it up a little bit. I didn't notice who had asked these questions. So there was another set of related questions that I combined here. There was the third question at the bottom of the screen for the first frequently asked question that I have marked online. It talks about the I-140. It says, employee can change employer if the I-140 is approved for 180 days and can extend transfer more than 6 years. That is true. How can an employee change a job if they don't have a copy of the approved I-140? I already addressed that. Is there a way to get a copy of the approved I-140? I already addressed that as well. Now, the other two questions are not a part of this frequently asked question, but I would address them anyway. Is it still possible to search LCA with the new system? I am so sorry. I have not gone online. Our team takes care of all that. I have no idea. Second question, with the new process for filing H-1B, can employee get notifications? The answer is no. I have looked at the new system, the screens of the new system. They will only allow lawyers or the employer to go in and take a look at the lottery winning cases. Okay. Star 5 on your telephone, folks, if you have any follow-up questions on these things that I've discussed. Please press star 5. Okay, so let's see. We have one question from Michigan. Okay, let's get to talk with Michigan. Yeah, Michigan, go ahead. We can hear you.
Hello.
Yes.
Yeah, can you hear me, sir?
Yes, sir. I can.
Yeah. Okay. So my question is, I have an I-140 approved from last 1 year, and I'm still with the same company,
Right.
but my company name is changed, and based on that, the company filed a new amended I-140 to reflect the change of name. Okay.
Right.
So I also got that approved yesterday. I-140, okay?
Right.
So my initial approved, I have an initial approved I-140.
Right.
Then I have an amendment approved I-140, which is recently approved, that is yesterday.
Right.
I am now planning to change my employer, but am I eligible to change? Because I have not crossed 180 days after my amendment.
Right. But the thing is, your original I-140 approval still covers you, because that stayed approved for more than 180 days. So you are fine. I don't see any problem with
1 year.
Okay.
Okay. So what if this company withdraw the new approved amended I-140?
I don't think it makes a difference.
Okay. I can still use my old I-140 and still use that for any of the H4EAD or a H1B extension, right?
That is correct. Okay.
Okay. Absolutely.
Good luck.
Thank you so much.
You're welcome.
Appreciate it, sir.
Bye-bye.
Thank you.
Okay, so let's go on to the next frequently asked question. And this one says, this is the new number 5. Impact on H4, H4EAD if the H1B holder changes jobs. We've also addressed this pretty much in every conference that we've done, but I'll revisit it. So what happens is, there are a couple of situations that people ask us about, and I'll look at the specific questions in a minute. But generically speaking, let's say that your spouse has an H4 and an H4EAD approved, which is good till 2022. If you change jobs, should they be filing H4, H4EAD again? The answer is no. Why? Because their H4 and H4EAD is not connected with the employer. It is connected with your status. As long as you're maintaining status, how many employers you change doesn't matter. Somebody just raised a hand. I'm not going to be able to get to that right now. Let me finish what I'm stating. But please keep your questions grouped together so we can keep all the frequently asked questions in one place. Okay, so you do not need to change the H4 and the H4EAD every time you change employers. You only need to extend them when there is about 6-7 months remaining. You cannot file an H4, H4EAD application before 6 months before the expiration. Okay, so that's the generic rule. Now the first question is, and I have to combine these two posts here also. The first question was from San1233. My wife's H4 and EAD is still pending with USCIS. Applied on 11th October 2019. Now I would like to change my employer, and new employer would like to initiate the H1B. Do I need to wait for my wife's petition to get approved? This is a little trickier. Okay. First thing I would need to know if you're on the phone is, when does her H4 expire? So, and when does your H1 expire? Yeah, if you have time remaining on your H1, you may not need to do anything right now. Change employers and get your extension. If she's got time left on her H4, she should be okay. If you're on the phone, press *5. I need a little bit more information. If you're on the phone, press *5. Okay, you're not on the phone. So I do not know unless I have this information. So if you got more than 6-8 months remaining on the H4, H4EAD, and your H1, there's nothing that needs to be done. But if your H1 is expiring soon and you are filing an H1 transfer and an amendment, I think you'll have to refile everything. because otherwise the approval that you do get for her H4EAD would be too short. So this is a judgment call. You may want to talk with your lawyers about this. The second set of questions were from Madhusudnan. I'm on H1B visa. I got my visa extension till December 2021. Wife has H4EAD and is working as a full-time employee. So what will happen to the H4EAD till the H4 got extension if I change employers? Right. So I just answered that question. Your change of employers is irrelevant. Your maintaining status is the only thing the H4 and the H4EAD cares about. In June 2021, you will apply for her extension. Before that, she can continue while you change employers to your heart's content. And it does not become invalid just because you change employers. I think I covered the questions. Okay, if you have follow-up questions on these, please press *5 on your phone while I take the call from, I think it's Pennsylvania. Area code 570. Okay, I'm not doing any new calls. So if you are, I hope that you folks know that. So let me go to Scranton, Pennsylvania first. Scranton, go ahead, please. Pennsylvania.
Good afternoon, Rajiv.
Good afternoon.
So whatever we discussed, right, is it also apply for the 140 amendment case as well?
140 amendment, it's a little trickier to answer that question. As long as, let's take it a step back. First of all, was the original I-140 approved and stayed approved for 180 days? At least one of those days was on or after January 17th, 2017?
Yes.
Okay. In that case, I would strongly hold that you are protected because you have already crossed the period. Now, later on, a company comes and buys out your company and they're filing an amendment. That's fine. I really don't care about that. You're already protected by the old case. There's a little area of doubt here, and I would not want to comment on that without looking at the law again. One area of the law is USCIS can pull some sleazy stuff. And it's really unnecessary, but that's the Trump administration's go-to move. They always do sleazy stuff. One of the sleazy moves they might want to make is try to revoke the old I-140 because the old job no longer exists. But my answer to that, again, speaking off the top of my head, is even if you revoke it, I don't really care. You can't really take away my right to extend my H-1B or my priority date because you are not revoking it for fraud or misrepresentation or gross error. But I have to look at it a little bit more from an academic perspective. From a practical perspective, I think you're fairly safe unless the government tries to pull a sleazy move, and then we would have to deal with that. Does that make sense?
Yes, Rajiv. Thank you very much.
Oh, you're welcome. Good luck.
Thank you.
You're welcome. Okay, so now we have a two more questions. One is from Chicago, and let's get the Chicago question first because you logged in earlier than New Jersey. So making sure I got the right person. Okay, Chicago, Illinois, go ahead, please.
Hi.
Yes, ma'am.
Hello?
Yes, ma'am, we can hear you.
Yes. My name is Tanu, Rajiv ji.
Ji.
Good afternoon.
Good afternoon.
I am trying to bring my brother here on
Tanuji,
family
I'm not taking random questions. There's a very focused discussion. Normally what happens is, you must be new, I will afford you that much leeway. But we are very focused and we just deal with the questions ahead. Normally I don't have time for new questions unless they are posted because I've budgeted time. But if you have a question that I can answer in 5-10 seconds, I'll try my best. Guys, don't do that. Please stay focused on the discussion. Go ahead, Anu. What was your question?
Okay, my question is, if I apply for my brother for family visa, he's an IT guy, and if he has to get an H1 in the same time period, will it be a problem for him?
Not at all.
If he's already applied
Not at all. A pending green card is no impediment to an H-1B. Okay?
Okay.
Good luck. Yeah, please guys, don't ask questions out of turn. I'm trying to keep it very focused. Okay. So this one is taken care of. Let's go on to the next one. Now this is another problem. I just did a consultation yesterday. What happens if I get promoted while the PERM is pending or it was approved? So I think off the top of my head, without looking at all the court rulings and administrative rulings and the regulations and the theory behind the regulations, from what I know, or I think I know, I can just say that unless there is a substantial change in the job, substantial change, what does that mean? Nobody really knows. So I would say if it's a more than a 10, 20%, 10, 15% change in the job, I would probably want to redo the PERM for the next higher job. Although there are several ameliorative or protective provisions in the law. So let's say I'm working as a software developer, but then I get promoted to a team lead. Do I lose the old labor certification? The answer is no, because you could always go back to the old job. You could take a demotion if it gets you your green card. So there are several theories based upon which something like this could be resisted, but it may not be the best approach. Remember, the trick in winning an argument with the government is to not get into an argument. So if I can do something cleanly, I would rather do it that way. Okay. So the idea is if there's a promotion, as long as it doesn't change the job substantially, you're okay. So you've used your role as a developer. PERM is to be filed as developer. H-1B amendment for extension will be done in the next couple of months. Oh, that's exactly it's almost like I read your mind. Technical lead. You're becoming a technical lead. Same place. I-94 is going to expire. PERM gets approved as a developer. Will there be any issue? I would rather have you consult your lawyers who know your case. If there is not a substantial difference in the two jobs, you're okay. And another theory is that you can always go back and take a demotion. But it's difficult for me to answer that question in the abstract. I've already told you the theoretical underpinnings of what I said. If I can apply I-140 as a developer, it gets approved. Do I need to apply further H-1B extensions post 6 years completion? So here is the weirdness, further weirdness in this system. So let's say I got my H-1B approved as a team lead, my I-140 approved as a developer. I filed my 485 when the priority date became current as a developer. After 180 days of that, I can take any same or similar job, including the promoted job. So I really don't need to do anything on that. But there are several legal complications before you get to that conclusion. It should be discussed with your lawyers in detail. But those are the theoretical grounds on which this entire area of the law rests. It's quite crazy. Many times it makes no sense. But to take a promotion requires an assessment where there's going to be a substantial change. And if there is, let's redo the case. If there is not, let's go on with what we've got. But in any case, we can always fall back upon taking a demotion if necessary. Star 5, if you have a follow-up question. And by the way, you don't have to change your H-1B back to a developer. H-1B is the current job. Green card is the future job. Today I'm working as a team lead. When I get a green card, I might take the job as a developer again. So today I must have an H-1B for a team lead because today's job is covered by the H-1B. No star 5 on this. Let's go on to the next question. Another one that's a problem, birth certificates. Neither my wife nor her sister has a birth certificate. My wife used affidavits by her mother in addition to high school certificate. Can we use similar affidavits? And the answer is yes. But normally what we recommend is that get a statement or a certificate of non-availability of birth certificate from the municipal corporation or the panchayat of the place where your wife was born. So let's say if she was born in New Delhi, get the New Delhi municipal corporation or administrative authority, whoever they are, to give a letter that says we have no record of this person's birth in our records. So if they don't have a record, non-availability, you can use then 2 affidavits. There is always a possibility of using secondary, tertiary evidence like Aadhaar cards, I guess, or ration cards and school leaving certificates, etc. So there is always that possibility. But usually the government does insist, and I think they are incorrect in that insistence, because State Department clearly lists that birth certificates in India before 1970 were not available. So they shouldn't, I mean, of course, if your wife is born after 1970, and I assume that she is, then you have to get the certificate of non-availability. And there's no particular format for it. It's just a statement from the municipal corporation saying there is no record of the birth. And then you can add 2 affidavits from people who were alive when your wife was born. *5 if you have a follow-up question on this. *5. Okay, there's no follow-up question. Let's see if we have any other frequently asked questions. Okay, we do not have any frequently asked questions. Let's go to the regular questions. So we did question number 2 already. That was a frequently asked question. Asylum cases, I'm sorry, I have no idea. I don't do asylum cases. Andy says I was counted twice in H1B. First in October 2006 and second in September 2009. So that's really only once, because if you left USA for 1 year, your quota gets reset. That means September 2000 onwards, you have 6 years again. I worked on H1B from October 2006 to September 2009, then left the US for good September 2009 through December 2010, 1 more year. Re-entered US in January 2011 on a new H1B visa after being counted against the cap the second time. So that means your 6 years began in January 2011. Then you left in September 2013 for good. And you've been outside since then. In December 2020, I filed for a 3-year cap exempt visa. I think that should be fine. They gave me authorization to work for only 3 months. So let's do the calculation. So beginning 2011, you used only about 2 years of H1B. So you still have 4 years of H1B. The fact that they gave you only 3 months could be because you could not prove the existence of a project beyond 3 months. They collated both times I stayed under. No, they can't do that. They can't do that. That's wrong. That is incorrect. They cannot combine the 2 times you were in the United States. Your time begins to run when you came the second time under the cap again, because you were outside for more than 1 year. So yeah, they have it wrong. By my calculations, if you go by the 2011 start date and you used only 2 years, you still have 4 years of H1B left. Second question is, I have an approved H1B valid from Feb 8th to May 8th of this year. Can I delay my trip till April 15th, 2020? And the answer is yes, and it should be refiled anyway, or the government should be questioned. Why are they giving you 3 months? They should have given you 3 years if you have a project for 3 years. This is getting too complicated, sir. I'm a little short of time. Not sure I can cover all these details, but the bottom line is, my perspective, if another new H1B, yeah, you should be able to do another H1B. And you can come in April, come back to the US again on, I don't know what you're talking about, October 2020. Are you on the phone, sir? Press *5 if you're on the phone. I'm very unclear about what you're asking me. Okay, you're not here. But yeah, definitely you can apply for the H1B, and I think you should be given 3 years, full 3 years. Next question is question number 8. So can I get into school when I have a pending 485 application? Well, it gets into very tricky areas. I have many clients and people from the community who were able to get F1 even though their 485s are pending, especially the MBA situation. What happens is you are working as a technical guy or as a professional, and you get admission into a good school and you want to take that opportunity, I personally have seen these cases getting approved, even with the 485 pending. But this is something I would want you to discuss with your lawyers in detail. There are several complications that you need to be aware of. I personally think there is a problem that the government can create. You're on an L1A visa. Government can create this problem that on the date your green card gets approved, you must be willing and able to take the job for which the green card was approved. Okay. So as long as you are willing and able to take that job and eventually do take that job, you should be okay. But it's a little complicated. I can't really tell you. Theoretically, I can tell you this. Don't withdraw the 485. That's not worth it. Do consult with a lawyer. See what the pros and cons of all choices are. If you're on the phone, we can have a quick discussion. Press *5 if you're on the phone. Okay. So this one is, let's see, from California. Okay. California, can you hear me?
Yeah.
Okay.
Hello, sir. Can you hear me?
Yeah, I can hear you fine. So the thing is, if you start in fall of 2020, would you be willing to take the same job on which your green card is based when you finish your MBA?
Yeah, so I'm willing to do that. I talked to my employers as well, and looks like they can extend an offer for after 2 years. I think my concern is mostly around the situation where, let's say, because it's an E1 category, the priority date becomes current before 2022, and I'm still in school. If the USCIS asks me for a proof of employment because they're about to approve the application and I'm still in school, I don't have employment, does that affect my application?
And because
my interview is already done.
I would want you to take a lawyer with you. When you go for the interview, they need to remind the USCIS that it's not current employment that counts. It's the offer of employment that counts. That's the law. So what you're doing right now doesn't mean a hill of beans. What matters is that you intend to take the job and the job is still open for you when you finish your MBA. Enough said. Okay. Now, what if this is where things get tricky and that's where you will need a lawyer to go with you. What if your 485 is or your interview occurs with a full year remaining on your MBA? Okay. Would it be an approvable case if I'm not going to join this employer for the next 1 year? And my approach to such a case, if I were sitting in that interview, would be that, look, officer, there is no law that says there has to be a certain period of time within which I must join back. It's a commercially reasonable time. And commercially reasonable time is determined partly by agreement between the parties and partly by the circumstances of the case. The circumstances are he's finishing his MBA, and when he finishes his MBA, he's got his job. Now, if you have only like 3 months remaining to your MBA, no question about it. You're fine. So if you have a lot of time remaining on MBA, it might get a little tricky because they do want you to join the employer once your 485 is approved. But how quickly is not written down anywhere. Okay.
Got it. That was my concern because my 485 interview is already done.
Right.
It happened in October last year.
Right.
But because the dates are not current, I don't have any decision yet. The only concern is in the future, because the interview would have happened like so many years ago, they might again ask me before approving my case to furnish some details of employment. And like the research that I've done so far tells me that I have to join after my green card or when my green card is about to be approved. And that's the gray area that I'm confused with. Like if there's still like a year left on my MBA, what does that soon after green card approval joining employment?
I have to look at the law, and I would suggest that because you have lawyers, why don't you have them look at the law? I remember I was reading a federal case the other day, just a couple of days ago. I didn't read the whole case, but there was a federal case that said, wait a minute, he's not supposed to have that intention to join that employer forever, never, never. So just look at those cases. There's a history of one case I do remember. which I read, there was an old case where something similar happened. Well, not similar, but the guy entered USA. He got his green card, and when he went to the work location, he found that the situation was very different from what had been described to him. He refused to join. And when USCIS tried to take away his green card, the court said no. He was willing, but the job was not what had been described to him, and it's perfectly okay for him not to join. He's not a slave. So there might be some cases out there on this issue. I'm aware of at least 2. So they should be looked at, and then your situation examined, and figure out a creative solution based upon how much time remains on your MBA. Difficult for me to give you an answer in the abstract. That's more like writing a textbook. Okay?
Yeah, thank you, sir.
You're welcome. Okay. So next question. Frustrated non-immigrant. Oh, I hear you, man. Filed my H4 with my spouse's H1 in premium. Spouse's H1 was approved. My H4 took 4 months. 4 months is nothing as compared to, we had to file a lawsuit for somebody who had been waiting 18 months for the H4EAD approved. Well, of course, as soon as the lawsuit was filed, government realized that they were quite in the wrong, so the lawsuit never went anywhere. They approved the case within a couple of weeks. But 4 months is not really that big a deal, frankly. I applied for H4EAD separately based on spouse's approved I-148 Phoenix location, but still waiting for H4 after 4 months. My H4 spouse H1 is approved till 2020. Now spouse employer, same employer, is ready to file H1 renewal. My AD is still waiting for approval. Will there be biometrics again? I have no idea. I think there would be. I don't remember. See, I don't take care of these nitty-gritty details. I am the law person. Most of the procedures are handled by my colleagues, my team members, who are much better at this than I am. I have no idea. I do not know. Can I file my H4 with spouse H1 along with EAD? I think you would have to file it as a new EAD because the previous one is not even received. Shall I ask my wife to file H1 in premium? I don't see the point of it. And I don't think there's anything I can advise you to make things get quicker. Only thing you can do is, it's a very interesting situation. I don't know if I mentioned this in our conferences. It's not happened to me in almost 28, 29 years of our practice. I was in the office and we had made a request for an expedite for an H4EAD. It was an H4EAD renewal. And we explained that this lady was working as a project manager for a non-profit organization that was involved in providing electricity in the rural areas. There were like 80,000 users, families, who would be without power if we were not able to complete these projects expeditiously. So we pointed that out. Now here's the interesting thing. I got a phone call from the USCIS. The officer, I must confess that I was very pleased. They wanted to talk with me, got on the phone with me, said, "Sir, what is the urgency?" And I did remember all the facts of the case, and I said, "This is what is happening. And really, it's for the U.S. interest to approve this H4EAD. Look at the employer's letter. It's so strong. Please expedite the H4EAD." He expedited the H4EAD on the spot. The H4EAD was approved, and we received it within, I think, 3 or 4 days. We got the approval. So that was a very pleasant surprise. The moral of the story is, if there is something that is in the interest of U.S. public or some humanitarian angle, for heaven's sake, don't try to make the angle that we need the money, because that's a public charge issue. But if there's a humanitarian angle or the employer is losing a lot of money if you can't work, there might be a possibility that they would expedite your H4EAD. Doesn't hurt to try, right? *5 if you have a follow-up question. *5. So try the expedite. Even though there's no premium processing, an expedite might work. Oh, folks, why are you so slow in maybe? Okay, this is New Jersey, I guess. Okay, New Jersey, go ahead, please.
Hi, Rajiv.
Hello.
Can you hear me?
I can hear you. Go ahead.
Yeah, hi. The only question which I have is, because my EAD is still not approved, can I file my renewal H4 along with the EAD, which says that taking the form which says that it's a new EAD and not the renewal EAD. Can I do that with this H1? That's the only question.
Cannot help you fill forms, because if I help you fill form, I have to sign the form. No, I can't help you fill the form, but I can tell you what you should do. First of all, first thing you should do is call the USCIS, explain the problem, and ask to speak with somebody, an adjudications officer. I think they call them tier 2 officer or level 2 officer. Most of them are quite knowledgeable. Okay. The frontline staff is working off a script. They don't know anything. The second tier officers are very, very good. They will also give you their first name. Write down what they tell you. Write down the date and the time of the call, and act accordingly. Okay. So this is really not that big an issue.
All right.
I don't think it's something you need to worry about too much.
Okay, yeah, because I was not sure that whether I should file the EAD form along with the H4 as well.
No, I personally think,
I
think you have to. I don't think you have a choice.
Okay.
Because your old H4 is about to expire, right?
Yes. So and EAD is still not received, the old one.
Definitely you have to. You have no choice. You have to file both H4 and EAD application together. Okay?
Okay. All right. That helps. Yeah.
Hang in there. Good luck.
Thank you.
Bye. Okay, so the next question is from Arjun G. Family-based green card for my wife, F2A. My US green card or permanent resident, which expires in June 2025. Living in India from Feb 2018. Okay, you have a re-entry permit. Oh, good. You had me worried there for a minute. I've approved N470. Very good. I am in India with re-entry permit till 2021. Can I file my family-based green card? Oh, absolutely. Absolutely. You can file your family-based green card even though you're outside the United States. And I discussed this in another community conference call with a online community. And I explained to them that you do not have to be, whether you're a citizen or an immigrant, you do not have to be yourself living in the United States when you file the application. But when the time comes for you to go for the consular interview, you must already be domiciled in the US, or you must be in the process of being domiciled in the US. So, because where they get you is the I-864, the affidavit of support. That requires that you must be domiciled in the US. So, close to about 3 months or so from her interview, you may want to just move back to USA. *5, if you have a follow-up question, I'll address the second part of your question in a second. Okay, so you wanted to know about the final action dates and the filing dates. What is the difference between the two? Well, it's a long story, but I'll give you the bottom line. The easy mnemonic that I tell people is, remember this: final dates are not final. That's a good mnemonic to remember. Final dates are not final, because if USCIS says you can use the dates for filing to file your application, you should. Whom does USCIS control? Only people who are inside US. So, first thing to remember, filing dates are final dates are not final. Second, if USCIS says you can use the filing dates or date for filing, you can, but that only helps you if you have a 485. If you're in USA applying for adjustment of status. If you are applying for a visa, only thing you can do is send your papers into the NVC if you have not already done so. That's the only thing that it helps you with. Otherwise, everybody just stays with the final action dates. So final action dates are not final. USCIS tells you when they are not final. They might want you to use the other set of dates that they publish. And also, it only helps people who are doing adjustment of status. Those are the broad rules. *5, if you have a follow-up question on this, *5. Okay, so Nisha has a question. Got an RFE on an H1B for clients SOW. They've only sent the invite letter. I'm released from the project. They're trying to find a new project. I-94 is good till March 2020. H1B can be expanded for 1.5 years. I've approved I-140 from Jan 2020. Can they change the client now while the H1B extension is still in process? They can, but you'll have to go outside USA for visa stamping. It happens all the time. It happens in our cases too. Would it impact negatively on the extension case? Well, yes and no. It's not a good situation, but if the project is over, it's over. The only thing I would be concerned about did the employer know that the project is going to get over? And if they did, then they shouldn't have filed the extension. You can do an H1B transfer also. Worst case scenario, Nishaji, you might have to go outside US. It's not the end of the world. It's a hassle. It can take time. But if you have a good case, then I don't see why not. And I've discussed the I-140 approval and how long it stays approved in great detail today. So you can go back and listen to that. I see somebody's hand is up. I'm just trying to see. We still have 4 or 5 more questions. So I don't have a lot of time, but I'll do the best I can. So, okay, let's see who has their hand up. This is also California. Okay, let's talk to California. Yes, California, go ahead, please.
Hi, this is a follow-up question with the one which you were reading right now. My name is Nisha.
Hanji.
What the company is suggesting is like I can go to their sister company and then do a H1B transfer there. But my question again remains the same, like what happens to I-140, since as you said that 180 days should be there, otherwise USCIS will not extend our post 6 years. So what happens to that then? And if everything goes in that jeopardized situation, then as you said that it's not the end of the world, you can go back and come stamp and come back again once I get the project. So will not that impact my I-140's the 180 days?
I told you that I have not looked into the law on how to protect you from the USCIS trying to revoke your I-140. I don't think they will. But I cannot really tell you that legally they can't come after it. I know they have tried to. I know there are cases they've tried to. They have nothing better to do in their lives. Okay. So they've tried to. But are they legally in a legally defensible situation? I do not know, Nishaji. You're going to have to talk with your lawyers, have them research this issue. You want us to do it, feel free to reach out to me. We'll do the best we can. But I do not know the answer off the top of my head. I think that'd be a very weak situation for them. Personally, I don't think it's a problem. Okay. So, but if I were you, and I'm forgetting all the legal niceties, let's look at the practical side. You need your H1B done to stay in the United States and work here. So I don't have a choice. I'm going to go for it. And I've got 1.5 years left. I can apply for another green card if I have to. Okay. I don't think you'll have to. But even if worst push comes to shove, you're okay. Don't worry about it.
Okay. All right. Thank you.
And by the way, you're in California, and California courts are pretty tough on USCIS. So if you are staying in California, 9th Circuit is excellent for immigration cases. Most of the times. Not all the time. Most of the times. Okay?
Okay. Thank you.
You're welcome. Good luck. Sometimes there are no easy answers, guys. There's no yes or no answer. We just have to plan for and take the minimum risk route. Shiv Suresh, I've been working with my current non-profit. Oh, by the way, I-140, whether it's approved through profit or non-profit, doesn't really matter. So will I be eligible for a 3-year extension based upon an approved I-140 which was filed by a non-profit? Sure. Will I have to get first my 3-year extension on cap exempt H1B and then move to working on cap subject? You cannot work on cap subject H1B unless you go through the quota. Should I wait for 180 days after my I-140 is approved? We've talked about that at length today several times. Follow up to question 3. If my H1B is picked up in lottery, when can I begin working? It's when October 1st is the earliest, whenever your H1B is approved. What if the H1B is still pending? I think you have to wait. You have to wait till the H1B is approved. No earlier than October 1st, but certainly you have to wait. Okay. Star 5 if you have follow-up question. Rameshji? Star 5. Okay. Sarath says, I have been in the US for 12 years on H1B. I-140 is approved. If my client and the employer agree for me to work from India for the next couple of years, can I work as an independent consultant? You can. I don't see why not. Do I need to set up an LLC for salary or for taxes? Not really. You can be an independent contractor. And this is really a tax issue, not an immigration issue. So that's really your choice. You can talk with your local chartered accountants and see what is the best way to do this. Can they renew my H1B? This is where things get tricky. I saw a very odd ruling from the Department of Labor, and I think that case was not really briefed very competently, in my humble opinion. Because what happened was the guy was outside USA, and maybe he was still working for the company, and the I think it was the administrative law judge with the Department of Labor who said, well, you got to pay his salary even when he's outside USA. I think that's a very poor ruling. I think it's definitely subject to challenge. So ideally, what I would want them to do is revoke your H1B just to be on the safe side. And this is something your lawyers can discuss with them. And then whenever you need the H1B, just apply for it again. Okay. I don't see any problem with that. Only thing I would be concerned about is that if you intended to take the green card job on a permanent basis, why are you taking a 2-year gap? And if you are taking a 2-year gap and there is a personal reason for it, mom is not well, dad is not well, or something like that, I want to be with my family, something personal, then I think it's okay. It should not cast a shadow on your green card. Just be careful with that. Star 5 if you have follow-up questions. Star 5. Okay. Rohit G. joined the same employer, same position on H4EAD in December. L1A had expired. We need to maintain H1 L1 status while 45 is being filed. But in my view, your situation is L1 is expired, but you are maintaining H4 status. I think that's fine. You don't have to have L1 status to get an EB1C. So you are okay. I don't see any reason why you should worry about it. And you can file 485 even while you're on H4, although your green card is based upon EB1C. So I don't see any problem with that. I'm not aware of any law that stops you from doing that. Star 5 if there is a follow-up question. And yes, you can file a 485 while I-140 is in process. I don't see why not. There is concurrent filing. Absolutely. Only thing EB1C is missing is premium processing. Otherwise, it's just like any other employment-based case. Next question. And this is the second last question. Let me do the last question. It's easier to answer. So this year, would there be a challenge to file more than one H1B through separate employers? There's never a problem filing more than H1B through completely unrelated employers for completely unrelated projects. That was never a problem, and that continues this year. Nothing has changed on the law on that. Okay, that question was easy to answer. So going back to the last question today, and I've got a couple of minutes before I've got to go. I'm currently in US on L1B from employer A, valid till 2021. Another 2 years to max out. They're not supporting my H-1B, so I want to apply for H-1B consular processing. Yes. So when you get an H-1B approved through consular processing, you can still be on L-1B, no problem. Can my H-1B approved for employee be transferred to employer A while I continue work for employer A? I believe so. If the employer A does not revoke your H-1B, if they don't revoke your H-1B, I think you can apply for a changeover. Yes. The only thing is, USCIS does not consider, and this again is highly questionable legally, they do not consider an H-1B to be completed until either the visa is obtained or change of status is obtained. So the only caveat I would have is that maybe that's something to be looked at, discussed with your lawyers. I would have to look at the law and see if there's any problem with that. But I know that's a potential issue. Can I change employer, work for employer? See, all of this is predicated on the same issue. Is my H-1B complete upon approval or upon stamping and change of status? And the answer is, I think it's the latter. Just approval is not enough. Either you have to get a change of status to H-1B or to get a visa stamp and come back in to be counted out of the H-1B quota. Okay, star 5 if you have a follow-up question on this, star 5. Very good. Folks, that's it for today. I'll see you again in 2 weeks. Thank you all for joining me. I always enjoy talking with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.